Thanks again for tuning in to the Law Office of Don Dennis, where we look to provide the law in plain English. So whether you have a white collar, blue collar, or no collar, we want to make sure everything makes sense. 1,000, 2 1,000, 3 1,000, 4 1,000, 5 1,000. 5 seconds. In 5 seconds, you can complete your entire signature on a contract. Just 5 seconds, but the repercussions and the consequences of that signature can last a long time. Tonight, we're going to talk about some of the possible consequences and some of the things that come up all the time with business owners. Problems that I commonly see occur are situations that keep people up all night long worrying, stressing out over how they're going to handle it. Makes people engage in all types of conversations with their families, friends, and coworkers, asking if they have a resolution or a solution on how to get out of the mess. And lastly, turning people into Google and Wikipedia attorneys. People that never even decided or thought about practicing law now are looking and doing extensive legal research to try to overcome their matter. Remember, ignorance of the law and claiming that you didn't understand something at the time you signed it seldom is a good excuse to present in court or to convince a jury as to why they should rule in your favor. You end up realizing you're stuck in a situation and you feel like you're sitting in the rain waiting on a rainbow. When I consult with clients concerning contracts, I'm not there to tell them their plans, their aspirations are a no-go. I'm there to provide them the know-how to make the deal effective and safe and in their business's best interest. I talk to business owners every single day, and one of the things I hate to hear is them tell me they signed some agreement, they're in the middle of some deal, and they agree to terms that are extremely harmful to their business. Terms that, although they're onerous, they're legal. And seldom is there a way to get out of it. On occasion, I'm able to help them, but oftentimes they have to abide by the terms they agreed to. Sometimes we get so anxious for profits that we forego carefully reading the paragraphs that we think are going to lead us to profits. So let's talk about some common problems that we see in contracts. First, bad profit participation percentage. Profit participation percentage is how much profit you expect to get out of every dollar made in the deal. So if the deal makes $100, are you going to get $10 out of every $100 sold? $5? $1? Oftentimes, to entice people to sign agreements, they get an upfront fee. And if you get the upfront fee, you figure, hey, I'll continue to get money like this as the deal goes on. But when we look at the royalties, your percentage might be 5%, 2%, or some other strange percent. And it's nothing wrong with having a percent of the deal, but is it the industry standard? Are you getting what you're supposed to get? Are you getting what's right? Or are you getting what's left? Oftentimes, clients realize after signing and after talking with me, they may not be getting the correct amount of profit participation that they are afforded and that they should be getting. In addition, just because in dealing with employers, a lot of employers think that you can prohibit employees that leave your company from competing against you. Therefore, they put in contracts, don't open up a similar business across the street from me. Don't do the same type of work I do in my city for 4 or 5 years. Well, although it's in writing, it doesn't mean it's enforceable. In the state of California, that is completely unenforceable. The California Supreme Court has ruled on it, and the law says the same. The California Business and Professions Code, section 16600, makes non-competition clauses completely unenforceable, except under very, very, very limited circumstances. And most contracts have a severability clause. What that clause does is says, hey, if one part of the contract is found to be void or unenforceable, the rest of the contract is still good and you still have to abide by it. Another problem that happens a lot of times when we're in a haste to make a decision is you negotiate with someone and they make all kind of great promises and get you excited, and all of the things that they're telling you is done orally. It's done in words. However, it's not done on paper. And when you get the final contract, all of the oral promises are not listed. And when you're talking with the other side, they say, go ahead and sign it. You know, we promised you this, we're going to do this, we're going to do that. But then at the very bottom of the agreement, there is an integration clause. And what the integration clause does is it says, regardless of all the discussion that we had, regardless of the sales pitch, of the puffery language, of all the things that enticed you to sign this agreement, if it's not written in this document, it's not a part of the agreement. And the document represents what the final agreement is going to be that's going to bind us in this deal. Most of the time, people get in these situations because they want to be do-it-yourself attorneys. What's a do-it-yourself attorney? A do-it-yourself attorney is someone that goes online, finds contracts that they think apply to their specific situation, downloads them, prints them, and starts using them. Or talks with a friend or colleague and says, hey, have you ever been in this situation? And they say, yeah, I had a contract. Oh, okay, well, let me copy it. And they copy and paste, sign it, and think that it's going to apply directly to their situation. Everyone should be treated unique and have their situations especially examined just based on their company's best interests and based on what they're comfortable with. That's how we all need to be treated. But if you're not preparing agreements and using agreements that were customly made for you, you could possibly run into these types of tough situations. You want to hire an attorney that understands you, understands your business, your goals, your vision, and your risk tolerance. If your attorney has never run his own business, has never lived, breathed, and thought about the business the same way that you have, the only understanding that he has about the business is what he hears from you and what he's read. Hiring my office brings to the table an attorney that has lived, eaten, and breathed a business, has made a profit off of a business and had to live off of it, has put food on the table based on profits generated from the business, been up all night making things happen because if I didn't make them happen, they weren't going to happen for my business to be effective. That's the type of attorney that you need on your team, someone that can relate to you. If your attorney cannot relate to you in all aspects of what you're doing, why is he your attorney? Or why do you use her? At this point, I rest my case.